Okay, so now we move on to the next segment of the evening, where Justice Ms. Prabha Sridevan will be in conversation with author Mr. Sriram Panchu. May I please request Ms. Prabha and Mr. Sriram Panchu to be seated on stage for the conversation.
Hi, good evening. Thank you very much for inviting me to discuss the book with you. On behalf of everyone here, whatever our heads might say, I think we all wish Justice Kalifullah and Sriram all the best. And with that, we'll send the elephant out of the room to go to the Gindi National Park and begin our discussion. I enjoyed the book very much, Sriram. And for me, the message of the book is symbolized by the language that you have used. It's both legal and informal, more informal than legal, which kind of tells us what mediation is. It's legal, it's rooted there, but it is very informal. And I enjoyed reading this. So we will now get on with the questions. Why did you write this book?
Former judge asks you a question, it's still tough. I wrote this because I felt that mediation has to move to another stage. Yes, we started through court-annexed mediation, and I think that was the right place to start, because the public needed to see the courts adopting mediation, embracing it, encouraging it. And that has traveled, I think, a considerable distance. So from 2005 to now, we have court mediation very extensively, thousands of mediators, lakhs of cases. But for mediation to really establish itself firmly, we need to have mediation before people go to court. Yes. And for that, there needs to be awareness. And commercial cases is a huge chunk of litigation across the board. And when I say commercial, I mean, civil, property, money claims across the range, corporate, and so insurance, banking, everything. And I thought that for that to happen, there needs to be more awareness. I mean, people have some idea about mediation. Sometimes they think, is it arbitration? Is it like arbitration? There's a little bit of, fuzziness there. And I thought a book which spelled out what mediation is, how it works, what its advantages, what are its limitations, where it can be used, where it can't, and how do you use it, how does it work, would, I thought, be of value. So I wrote it in a very simple way, for somebody who's not a lawyer to do. But I must tell you, the idea of this book came from Mr. Deepak Parekh, chairman of HDFC. Was a great supporter and a believer of mediation, has mediated cases, and he said, Sriram, to how many people can I go around saying that it's a great idea? He said, write a book. Write it in such a way that you can get that person to read it on a Delhi to Mumbai flight. Yes. And if you have hooked him during that flight, you would have achieved your purpose. Delhi to Chennai is a slightly longer flight, so I hope I will do that.
Thank you. After reading your book, this is the question that came to my mind. I don't know if you read Agatha Christie. There is a book which is titled, Why Didn't They Ask Evans? Because Evans is the person right there who should have been the witness to the will. But somebody else is asked, and that is dicey. So I felt, why don't they mediate at the beginning? What do you think are, apart from what Mr. Gandhi said, ego and suspicion, is that all? Or are there other factors that come in the way of, let's solve the problem?
Yeah, I think the adjunct to conflict is destructive behavior. It's a natural lead-on from conflict. Yes. The adversarial mindset, it's an me versus him. He's done this to me. I'm going to get him. And that is fueled, I think, when people go to our adversarial legal system. Till now, very few lawyers say, well, there's another way of doing this. Yeah. No lawyer picks up the phone and says, I'll speak to the other lawyer and see how can we sort this out. Our system has been built on adversarial behavior. And that's an escalation, it's a spiral. Your notices and the pleadings are all like, accusatory. Yeah. And then you go through a court and then somebody wins and somebody loses. And losing is difficult to take. So you have one more spiral. So somewhere you need to break this. And I think the way you try and do it in mediation is that by you introduce something, you introduce a process which is consensual. You introduce a person who's cast in a different role. And you introduce now a system, I think, where you can say, well, we're structuring it in such a way that you can actually take your case to a mediator and then you can see whether that process works for you. And I think the charm of this is you're not imposing anything on that person. Yeah. He's not under risk. The litigant he or she is not under risk. The mediator can't impose a solution. The agreement is completely in the contestant's hands. It's confidential. So what do you have to lose? So you're giving that person an alternative, which is the total opposite of litigation. Litigation, you're at total risk. The decision's not in your hands. Somebody will tell you what to do. In a mediation, it's the reverse. It's no risk. So I think, and that's one of the ideas why I wrote this, if you introduce the concept in people's minds that when you're in conflict, you need not follow the kind of, the usual route. Here is another route. And all I'm saying in this book is consider it. Consider if you want to try this for your conflict, your dispute. And be aware at all times that if this doesn't work, at any time you can go back, to litigation. You haven't lost anything.
Yeah, that's true. You just now mentioned that the lawyers use combative language and they don't pick up the phone and talk. Would I be right in saying that if the lawyer did that, the litigant might very well say, what is this to say in Tamil? How can you do this?
You're absolutely right. What do you think? You think I don't have a case?
Yeah.
You think I have a weak case that you should pick up the phone and talk to the other side? Absolutely. I think what we have done, by the fact that mediation is now a structured process. Yeah. And a good part of that structure is the court, the judge actually telling parties, why don't you mediate? Now, the minute you do that, then it is a court which is saying it. That is one. The second part, I think, of that structure is if the law mandates it. Now, when you have pre-institution mediation, now the law mandates it, saying that before you go to court, you must try a mediation. So I think that way, you get the impetus coming, from somewhere else, till this becomes more instituted like a culture, and then I think it becomes ingrained. One thing I must say about lawyers, when we started mediation in Chennai in 2005, I had a lot of, doubts as to whether it would take off, whether lawyers would see it as something which is unfriendly for them. And in the first round of, asking people to be mediators, I had to go after, senior lawyers and say, please come and be mediators. Let's try this. In the second round, after people saw what mediation was like and what kind of work it was and how it was being received, when we opened up training for round 2, we had 30, people to train as mediators. We got 150 applications to be trained, and that's been the same ever since. So somewhere the legal community, I think, has taken to it for a variety of reasons, and at a kind of a philosophical level, as Gandhi was saying, but I think this mediation has tapped into something which is in a lawyer's heart and psyche, to be also seen as somebody who brings about a betterment in the life of his client.
That's nice. Yeah, you've spoken about the role of lawyers. This is again something that I've already asked you in a different way, but I will still go. There is so much depth and breadth in the mediation process. As Justice Kaul said, it's more creative than any other, more scope for creation and innovation in mediation. And courts can't do that.
Courts can't do it.
Courts can't do that. And you've given some very innovative examples in the book too about how innovative solutions have come. Multiplicity of litigation has been reduced by a good mediator or a mediation process. So how do you, what would you say is the specific preparation and participation in the mediation process?
I think, I just want to take off from something you said about innovation and creativity. And Justice Kaul gave a very good example of, that manufacturer of jeans who sues somebody in India who makes, and then the defendant ends up being the supplier to the plaintiff. And I'd like to give you another example of that creativity. Many years back, I was mediating a dispute in Bangalore where this company had given a large amount of, raw material to a converter to be made into alloys and castings. And this man sold that material. He put that in the share market thinking he'll make profit and then buy back the material and then, do this conversion, give the castings to the company. Harshad Mehta came along, the share market tanked. And there was a situation where, the company had given it to him. He had, he didn't have the resources to pay back. The amount was about 6 million. And we sat in a mediation and this whole thing about options, how can we sort this out? And there were no answers at all. He didn't have the money. He said, I'm wrong, I admit it. I don't have the money to pay. And then we said, what are the options? What are the ideas? Nothing came out. And there was then one junior officer at the back, sitting at the end of the table. And he kept putting up his hand, and I would look at him, he'd put it down. Then I said, you have something to say. Just put it on the table, we need ideas. And he said, we should continue to give him material to convert. And this was an outrageous suggestion. He's just, stolen robbed your company of 6 million. And he would have got the sack if, I hadn't been there. No other solution was possible. We took this up. And from this, we worked out a solution and the company continued to give him material to convert. He was enabled to keep his factory going. The livelihood of his 25 employees continued. Sometimes they don't enter the picture in litigation. He could take on other work. The company put their accountant on site who kept control of the finances. In 3 years' time, this man paid back that 6 million. They wouldn't have served notice on him and got the proceeding underway in 3 years. They'd gone litigation. And the other thing was, their relationship improved so much that when the company finally had to cut down on the number of suppliers, they retained him. And I think that's another part of mediation.
Yes.
It improves relationships.
It improves relationships. And therefore, I think for business
it's important.
company disputes, I think it is very, rather than tearing the family apart, I think something gets done.
This is the other thing.
Mr. Srinivasa Raghavan said now they have a mediation clause in their contracts. Now, when it's a dispute relating to public sector undertaking or government and they come to you, no, they don't come to you because they are afraid that at some point somebody says, why did you make this option? They are always afraid and they prefer that a judge gives a decision. So that maybe you won't do it, but in a government it doesn't work that way.
Let's be clear. I think there is, a paranoia now in government officers that if we settle, And every settlement means giving up something.
Giving up
You have to give up something in order to get something. And no matter what, that the getting may be a lot, if giving up is a problem, and tomorrow, because of whatever reasons, you're at the receiving end of a prosecution, investigation, by any of the dreaded three C's, the CBI, the CBC, Central Bureau. Why will somebody do that? So this is the problem now with litigation where government is a party, that even when it makes supreme sense for settlement to take place, it won't happen. The officers are rightly and justifiably scared. What I have suggested in this book is a system by which you have a very high level clearing committee, screening committee, and let's say that's comprised of a senior retired judge of the Supreme Court. You can have on it, anybody from government. You can have the CBC. You can have nominees of the CAG. You can have people who are secretaries of government. Have pack it with as high as you want. And when government is a party in a litigation, let a negotiated settlement worked out, and the officers take it to this committee and say, "This is what we have worked out. Now you tell us, is this acceptable? Is it not? Or do you want modifications?" But once that receives the approval of this committee, it ought to provide immunity.
Yes.
And I think if you do that, you would have opened the way for government disputes to go to settlement.
That's one of the best ideas in the book, and I hope that's taken up. And I mean, it drives the bogeyman out of the room for most of the government officers. This is something, Mr. Gandhi, I wrote too before I heard you speak. See, beyond the binary space of you and I, mediation seems to move people towards an us space. So can you think of mediation moving into a greater area of the community rather than limiting ourselves to courts and curial disputes?
I think many disputes involve people more than the litigants themselves. And once you broaden it out to an us, I mean, in a matrimonial dispute between husband and wife, there is also often a child.
Child, yeah.
And when you open it out, then that us is there, including the child. Many disputes will involve members of the family, especially in India where you have so many family businesses. So many disputes involve members of the family. And those disputes destroy relationships between members of the family who often have had no part to play in this. But the peripheral family, succeeding generations all get caught up in this dispute. I've seen cases, I've handled cases where you have children and grandchildren and cousins who do not talk to each other simply because their grandfathers or their fathers fought. Okay? And when you say us and you broaden it out, then you get into community disputes. And you get community, and not just, you have neighborhood disputes, you have community clashes, and you have the far, wider arena of public disputes. So I think it's a widening, stream. And I completely agree with you that, it's not just binary. It's not binary. It's much more, than binary. And as it gets wider and wider and wider, is I think where you feel the full impact of mediation. But if I may take a slight twist to your question. One is that it grows wider. I think the other that it grows inside you.
Yeah.
And in a lot of times I had people come to me and say, look, this is not just, training us how to deal with litigants. These are also life skills. The art of listening, listening to the other, which we often don't do when we are in conflict, the art of listening. Also, I think understanding that each one comes from somewhere, and to try to understand this. When people are in dispute, it's very easy to lock them into saying you're right, you're wrong, you like this, you like that. But to have the understanding that each one in a dispute is coming from somewhere, an experience, a background, a being open to influences around them. And I think when you have that understanding, it's not just good for mediation. I think it helps you in life to negotiate life.
In fact, I think this, you mentioned listening. That's the thing that most litigants want. And their own lawyers, in some ways, are going to say yes. Whereas you as a mediator, you are not saying yes, you are not saying no, you're just listening.
You're listening.
And that maybe it kind of detoxifies the space. Your mediation is really a detoxification.
It is. And I think it's very important for them, that somebody out there is actually listening to them and listening to them for as long as they want to speak. I will never place a time limit on somebody who starts his first session mediation, because I know that it is important for that person to vent that feeling. And unless you actually allow them to vent that feeling, they will not move to the next step of resolution. That's one. And I think everybody wants to be, that litigant does not want you to agree with what he's saying. Yeah? His validation is not that he wants you to agree. His validation is that he wants you to understand. Yes? And to give him that importance of being somebody whom I'm prepared to sit and listen to as long as he wants. So listening, I think, absolutely.
Listening, yeah. Do you have this Zen story of the cup being filled and he keeps pouring? And the disciple asked the master, why you? Then he says, until you empty your cup, where will I pour it? So I think you are like the empty cups which is willing to listen to their bile until the bile gets diluted and they are ready to look at each other as human beings.
As human beings, yes.
Yes, our 5 minutes is up, and so now we open it to.
We'd now like to open the floor for audience interaction. Just in the interest of time, a small request, however, to keep your questions crisp and also wait for the mic to be passed on.
This is more about the international system, mediation in context of anarchy. Do these dynamics still hold? How does it work? When there is no supreme authority, no kind of legal system to take recourse to, or the legal system is weak enough that it can't impose a solution on the parties. How does mediation work in an international system?
Well, I think that's at multiple levels, that question. Part of that, I think, could be answered by talking about commercial disputes internationally between negotiating parties who are from multiple countries. And there is now a convention coming into place, by which mediation agreements are enforced globally in signatories to that convention. But if you're talking about, outside that space, then I think mediation comes in, through different areas. You have a court coming into process, but you have it where it is unstructured, the way you're saying. When it must come from communities, it must come from political leadership, and it must come in the enlightened public thinking sphere.
So it's Bharat here. I'm extremely thankful for luminaries like you to have mediation brought into mainstream actually. To come to think of it, the Commercial Codes Act, which has come in recently, has in fact Order 13, if I'm not wrong, which says if you don't have an interim or interlocutory prayer, then there is a compulsion for the litigants to go through pre-suit mediation. Question to you is, which other laws could possibly be having such compulsion that if there is no interim injunction, please compel your parties to go to pre-suit mediation?
I think we should try it first with commercial cases. We should try it and see how that works, how well it is received, how well it works, because you need a huge structure to, to be put in place for that. You're talking about pre-institution mediation in all commercial cases, and this starts from a very low limit of 3 lakhs. So you need a whole structure, you need systems. So I think we should really try, work this out, experiment, find, good solutions, good processes before we think of extending it. But if you were only to do it in commercial cases, I think that's a huge relief for the system.
Good evening and thank you for the talk. My question is on mediation in cases where there's a huge mismatch of power between both the parties, because how do you even get them to the mediation table? Thank you.
Good question. When there is a very severe negotiating imbalance, you either don't mediate or you mediate very, very carefully. Yes. And you must also always be sensible of that line. Very often we think, if there's an imbalance, we shouldn't mediate at all, let it go to a court. But we should also bear in mind that in a court, the negotiating imbalance can also be there and can have an effect. But I think in cases where the imbalance is too great, one should not mediate. A judge, after all, has the corrective power of justice, to remedy an imbalance. The mediator doesn't have that. So one should be very careful that when there is an imbalance, up to a certain point, one can mediate. And I think even while mediating those cases, one should be conscious of the kind of imbalance. So somewhere a skillful mediator will try and,
Sriram, in the pecking order of litigation, there is mediation, there is arbitration, and of course there is a court of law. And how do you think mediation and arbitration can coexist, and how can they work together to make it more meaningful?
Thank you, Anand. I think that's an excellent question. I think there are a lot of synergies between mediation and arbitration. And I think you can have them work conjunctly at different stages. I remember when Justice Kaul was here as Chief Justice, and he had to appoint arbitrators under Section 11 of the Arbitration Act. And very often he would appoint the arbitrators, but say, I'm giving you an interregnum of 30 days, during which time you should mediate. And very often that would be successful because parties would utilize that time. It's also that, during the arbitration process, at any time, I think arbitrators, if they feel that the matter can be settled, they should send it to mediation. I'm not in favor of arbitrators themselves mediating, because if you have to mediate well, you have to sit, in separate sessions and hold confidential discussion with parties. And if that doesn't succeed, as an arbitrator, you shouldn't be having confidential information with you. So I don't think arbitrators, should go off mediating and then come back to arbitrating. Far better to send the matter to mediation. If it works well and good, if it doesn't, come back, and let the arbitration proceed. So I think there is a good case for, combining the two. There is one possibility which I have tried very often, I think with very good success, of an arbitrator attempting mediation without the risk of confidentiality being breached. And that is where, I'm an arbitrator, I hear everybody, I make the award ready, I bring it to the table in a sealed envelope. And then I ask parties, and we have worked this out ahead, I said, would you like to mediate? If you don't succeed, you can talk to me as a mediator. If you don't succeed in mediation, it's not going to affect the award. The award is there. Okay. Do you want to try? And times without number, they've always wanted to try. And I think more often than not, they've succeeded. I don't know how much time I have, but if I have a couple of minutes, I'd like to give you a wonderful example. Do I have a couple of minutes? Yes. I think. All right. We can cut down the. This is the case of an old lady who had given up her share, in a piece of land for development. It was organized by her nephew, and the land was was developed. Flats had come, and flat owners had taken shares. And then she thought that she hadn't been given her due share. Well down the line, she said, I'm going to cancel these shares. And they all sued her. They took her to court claiming damages and that she must fulfill all her the conditions and sign everything. Came to arbitration, and I was the arbitrator, and she had a hopeless legal case. She had a hopeless case. But I thought she had a point. And we did this. I wrote the award, and in the award, I'm not going to mention figures. In the award, she was down, quite heavily. We went into mediation. And in mediation, a completely different set of factors came into play. Where a builder said, he said, this is my son's first enterprise with me. I don't want us to go into this kind of a problem. And family members opened up in a completely different way. And at the end of the day, in 2 hours, somebody who started with an award saying has to pay a large amount ended up with a settlement where she gained a very large amount.
Oh, wow.
To me, that case brought home very starkly the distinction between arbitration and mediation, whereas in an arbitration you have to go only by law. And a mediation, not just in you as the neutral. The point is that in a mediation, the thinking and the mindset and the approach of the parties, is so radically different.
Because this, my son's first business should not have this shadow of, all that won't figure in an arbitration or a litigation.
No. Nor in, better human impulses coming to the fore.
Yeah.
Mr. Panchu, the way we want mediation to come in the system, I think we'll need a whole larger lot of trained mediators. Presently, to my understanding, we don't have that kind of quantum of trained mediators in our country. Do you suggest that it should be a part of curriculum in the universities now, so that the young lawyers and judges who come in the system are already trained and oriented towards this?
Dr. Justice Kothari, yes, absolutely. I think mediation should be a part of the curriculum for law schools, but I think not just for law schools. I think it should be there in business schools, and I think it should be taught in the IAS academy. Yes. I think very often I'm asked by young lawyers, do I think whether there's a career in mediation? And I wish I could say that right now that yes, there is a career in mediation. I'm hesitant to give them that answer. But I think there will be. There will be. And I think that there will be that if mediation becomes something which is professional. And I think it becomes professional, then people will take to it as a career. And when they take to it as a career, there will be, specializations, there will be expertise, there will be focus. So that is a way I would really like to see it grow. And I think this little book is part of that endeavor. Sir, before you say something, I must say something. I'm so delighted that Justice Shah is here. And I think it is especially befitting because in 2007, he was the one who released my first book on mediation.
Shriram, my question flows from what Justice Kothari has asked you and your answer. So, there is a total lack of professional mediation institution in India. Now, we have statutory provisions about court-referred cases, whether it is in the CPC or even the labor laws, I would say, family court. But we don't have a legislation which would encourage pre-court mediation. Before the parties go to the court, they would really explore the possibility of going either to the individual mediators or to a mediation institution. So that is completely lacking. I mean, I heard from several mediation activists, and in many countries, when the dispute starts, then naturally they would look for the names of the mediators and ask the other party whether he is agreeable to go to the mediator. So, and you remember that we toyed with this idea when I was at the Law Commission to have some sort of a standalone legislation for this to encourage. Actually, your book is about this. It's directed. The whole idea is that the commercial parties, before going to court, should explore mediation. And these clauses in the contract are not sufficient because these are very routinely, mechanically mediation. Is rejected finally. No settlement occurs. So, do you think that there should be an independent legislation or the government support to encourage this pre-litigation mediation?
I Completely, I'm with you, sir, on that. I remember that we had meetings when you were chairman of the Law Commission, and there was this need felt then that we should have a Mediation Act. I think a Mediation Act will be of great value because it will, clear some of the present confusion that is there in Section 89, which is not drafted, I think, to wholly satisfactorily. It will also, I think, enable us to take note of particular requirements for mediation, put in things like immunity, see where parts of the Contract Act about agreements ought to be kind of changed a bit in order to permit mediation, to provide for this whole system of court annex mediation. We don't have, even our mediation centers in the high courts don't really have statutory basis, nor does a committee like the MCPC committee have a statutory basis. To provide for pre-institution mediation, a structure for that, as you said, to be able to go to mediation before coming to court. So for all that, I think we need legislation. It's a crying need. Also, I think to be able for judges to levy costs on parties for unreasonably refusing to go to mediation. I think that is another area which needs to be looked at.
Can the process of mediation be compared to the process of psychological counseling of the clients? See, you are bringing in cordiality where there was hostility previously, and you introduced an element of empathy in the place of antipathy of the parties to the dispute. Can it be called as a psychological process?
Well, there is a certain amount of psychology involved because you're dealing, after all, with human beings. You're dealing with human beings who are facing problems and who are going through stress. So there is a certain amount of, I think, psychology involved in being able to deal with them well. But a mediator is not a psychologist, and a mediator is not a psychiatrist. And mediators don't go into that field of, they're not helping people. The essence is not to help people, handle those issues. The essence of mediation is how do you get them to a solution which will then better their lives.
So I have a question for you. Thank you.
Yes, sir.
So in my conversations with lawyers representing clients in mediation, I think one of the major concerns is that there will be a reduction in their fees because mediation is a process which has much shorter timelines than a typical litigation or even arbitration. So how can one address that concern?
Yeah, it's a very it's a real concern, and it's a concern which needs to be addressed. And I'm going to address it specifically in the area of commercial mediation. In commercial cases, parties will have lawyers with them in mediation. And I think the answer is to evolve this thinking and this culture that the lawyer is assisting the parties in a professional way in the mediation, that there is a role that the lawyer has to play. Justice Sridevan asked me earlier, and I think I kind of didn't answer the question fully, about preparation in mediation. There is a preparation which is done by the party very extensively, but there is also a preparation that needs to be done by the lawyer. Preparing for the case, knowing the facts, the law, the issues, and working with parties on, what are the bottom lines? What is our negotiating position? How do we secure our best interests? So there is, an extensive professional legal role for lawyers assisting clients in mediation, for which lawyers must be remunerated professionally by parties. So I think more and more as mediation grows, it will become a professional activity and will lead to professional incomes.
Namaste. Up on your left. In your experience as a professional mediator, have you come across situations where a compromise, or what you call the essence, is to find a successful outcome which betters both parties? Have you come across that kind of a compromise, if I call that, in conflict with justice? And if you have come across that, how have you dealt with?
Very good question. Getting such good questions today. Mediation and justice. I'll answer that in two ways. As a mediator, I feel that ultimately, when two parties decide what they want, taking into view the larger perspective in their own eyes, I think that is a justice above all other forms of justice. So this is what they want when they take everything into consideration. That is one. Two is that some mediation solutions are obviously unjust. If there is an agreement between husband and wife which does not provide adequately for the child, that is an unjust agreement, and no mediator should sanction that agreement. If there is an agreement between two companies over, let's say, effluent being deposited on the neighbor, and so that they agree to, dump it in the nearby river, that is an unjust agreement. It is against law, and mediators should not let that pass them. But I think overall, a person's idea of what they want is possibly better justice than what a lot of systems can. Ultimately, I think it's about parties' autonomy. It is their problem, their lives. And so long as they reach that solution well, without coercion, and with knowledge of everything that is relevant, I think that's.
A body of case law has been developed over time by publication of cases which are in the public domain. Is it in some way possible to publish actual cases and the outcome of these mediation efforts without breaching confidentiality, without giving the names of the parties, but actual live cases, so that people believe more in mediation and awareness, greater awareness is created?
I think there is, there's nothing like actually seeing cases or reading about cases that have worked and, examples of mediation which have worked. It does a lot. But I think great care has to go into the confidentiality aspect so that you don't divulge, certainly not identities, and certainly not too much by which identities are known. Yes. But yes, for a body of literature, for a body of work to come up, which focuses on cases, and I would say the idea is to show the possibility of those cases. The attention is not so much on that individual case, but to show that cases like this, can be brought to mediation, can be settled. So if that is the kind of way it is written, of course there is a strong need for it. Sir.
There is a book which was published 2 weeks back. It's a book by a retired judge of Bombay High Court,
Roshan, yes.
So she wrote a book called Tangible Justice. She has not disclosed names, but some of the cases are about her attempt to mediate in the matter.
Right.
Perhaps that is a kind of a collection of cases where mediation has worked.
Vanitha, before you close, I just want to thank everyone. Can I do that now? Before Vanitha takes over, may I just express my thanks to Justice Kaul for being so kind to come all the way from Delhi to be with us. It means a lot. To our distinguished special guests for today, to my dear friend Sri Gopal Krishna Gandhi for agreeing to release a copy of the book, to Mr. Robert Burgess, thank you so much for agreeing to come and to speak, to Mr. T.T. Srinivas Ragan, equal thanks. Two very special guests me today. Justice A.P. Shah, who was in town, I got to know only this afternoon, and I called him and he said, of course I'm coming. And I think my day was made complete. Khalifullah Sahib is not here. When Justice Khalifullah came, I think he could only come for a short while, but I'm so grateful that he came, made my day complete. And thank you all, everyone, for coming. Mrs. Kaul, thank you for coming. Thank you all, everyone, for coming. It really, and I have so many judges of our High Court and former judges, Justice Basha is here. Thank you all. It is really, I think, my day couldn't have been more complete and more fulfilling. Thank you so much. And thank you, Prabha, for this conversation. And last but not least, Vanita, thank you so much for the tremendous work you put in. And last but not least, and one to acknowledge just before you is Sri Chandra, my publisher of Oakbridge, and thank you so much for this. Thank you again. Thank you.
Good things. This evening comes to a good close. Thank you, Sriram, for being here with us today, choosing CIC as the platform to launch your book. And just not thank you, we would like to wish you the best. You've been entrusted a very important responsibility along with your panel. So good luck to you. And thank you all for being here with us today. Thank you, sir.